The hearing will start now. Originating applications 381 to 385 of 2022, Zipmex Company Limited and other matters.
All right, thank you. Morning, Mr. Jonathan Tang for the applicants, correct?
Yes, Your Honor.
All right, let me resume allocation. So parties are reminded that there is to be no unauthorized photography or recording in any form and no dissemination of any photographs or recording of these proceedings. And only those counsel or persons notified to the court should be present at its location, and parties should treat these proceedings as they would a physical hearing. All right, give me a moment, Mr. Tang. Let me just check the attendees. All right, thank you. All right, we have a number of matters this morning. We've got the extension of time application, as
Yes,
well as the application in relation to the administrative class. And I understand you also got an application for sealing, I believe.
Yes, Your Honor, but I'm not sure if it's been fixed to be heard today.
Yes, it has been. I've directed for it to be heard this morning. I think it's been conveyed to the registry, so it may not have got back to you yet. Let's take the sealing application first. Could you just describe in general terms what your application is and why you require the sealing?
Your Honor, would the sealing application be heard?
Yes, it will be heard here. I just need you to indicate in general terms what it is and why you're asking in general terms for it. All right.
Yes, Your Honor. The sealing application is in respect of an affidavit filed, which is the 13th affidavit, enclosing the share subscription agreement that was entered into between the investor, the company, and two other parties, Your Honor. Each of the parties have their separate reasons for requesting for the sealing, which are set out in the 13th affidavit. And that is why we have filed the application for sealing of that particular affidavit. The SSA is intended, Your Honor, to provide the court with a copy of the SSA. We have filed a 12th affidavit informing stakeholders and creditors that the SSA has been signed. And the 13th affidavit is to provide the court with the copy of the SSA ahead of the extension of time applications.
All right. So in broad terms, you require a confidentiality in respect of the various parties, correct?
Yes, Your Honor.
Commercial confidentiality. All right. Done. Did you have a separate summons application for this, or not? Just
yes, Your Honor.
All right, you did.
There is a separate summons in OA 383.
What's the summons?
I saw. Just give me a moment, Your
Yes.
Honor. I see it as being summons 4325 in OA 383.
All right, thank you. Hold on a moment. All right. All right, so for the record, I will grant the sealing of the 13th affidavit given the commercial confidentiality, which is, I think, apparent on the face of it. So order in terms of prayers 1 and 2 of, summons 4325. All right, if any party subsequently raises any concerns, I will hear them out. All right.
Grateful, Your Honor.
All right,
Much
thank
obliged.
you. Let's proceed then to the extension of time application. And we'll take that first, and you can perhaps give me a summary at this point of the current status.
Yes, Your Honor. The extension of time applications are summonses 4184 of 2022 to 4188 of 2022. What I intended to do, Your Honor, is to take the court through the various steps taken in the restructuring so far since Your Honor had last granted us the extension of the moratorium. I would then have wanted to take the court through the restructuring plan for each of the subsidiaries and why a 4-month extension is necessary. And then I would have finally wished to take the court through the administrative convenience class.
We'll take that separately later. All right.
Yes, Your Honor. Would that be a viable outline?
Yes, yes. All right. We can proceed as you've indicated, except for the administrative class thing. I will have some questions in relation to your EOT application first. We'll deal with those and then we'll move on to the administrative class application. Right.
Yes, Your Honor. So just as an overall summary and to recap, back in August, Your Honor had granted us a moratorium until today. This moratorium expires today. During this initial moratorium period, the company being Zipmex Asia and the rest of my clients, being the group collectively, have been negotiating the share subscription agreement, the SSA, with an investor, right? I am pleased to update that the SSA was finally signed yesterday and is legally binding as of this morning because copies have been delivered to our clients, right? In addition, Your Honor, and I'll go on to describe the terms of the SSA in detail later on. In addition, Your Honor, during the initial moratorium period, each of the subsidiaries have been engaging with their respective regulators. This is in Indonesia is Bapepti, the Thai SEC, MAS, and in Australia is OSRAC, right? I think the most notable update to date, Your Honor, would have been the Indonesia reallocation, which Mr. Lim has described in his 10th affidavit, which is a response to Bapepti's requirement that all Z wallets in Indonesia be effected or reopened immediately by 4th November. Due to the reasons set out in his 10th affidavit, we had to do that as a matter of urgency. Unfortunately, the SSA couldn't be signed by then. So Zipmex Asia extended a temporary loan to Zipmex Indonesia to make up the shortfall. That's what we have termed the Indonesia reallocation. I think it is important to highlight, Your Honor, that the SSA itself provides for a top-up of the Indonesia reallocation. So the company is not technically, well, it is technically out of funds at this point in time, but it is anticipated that it will not be out of funds on completion of the SSA. The other thing to highlight is that Zipmex Asia has sold various assets to generate working capital. These are the P2000 transaction. The other transactions, Your Honor, that were set out in the 10th affidavit, there are 3 in total. These have been successfully sold and capital proceeds have been received by Zipmex Asia for the group's total working capital. So, Your Honor, if I may proceed, I will go on to the restructuring plan. The restructuring plan, Your Honor, is driven by the SSA. If I can just proceed to describe very briefly the terms of the SSA. It contemplates a total investment value of around $99 million in both cash and digital currency. The cash component is 30 million, digital currency component is the rest. In consideration of this, the investor will be issued shares totaling 90% of the enlarged share capital of the company. So basically, Your Honor, the investor comes in, takes 90%, and in exchange, it gives us this 30 million USD in cash as well as the digital currency. The investment is tiered in tranches. Originally, there was supposed to be 6, but because of the timing of the signing, it has now been cut short to 5, right? The first tranche is a cash loan of USD 3.24 million. In reality, the loan itself is 2.1 million because 1.14 is fees that are due to be paid under a separate transaction involving the investor and Zipmex Asia as well. They are buying Zipmex Investment Limited from Zipmex Asia. Right. The second tranche is also anticipated to come in early next week. This is a cash loan of 1.25 million USD. The third tranche is by 30th December 2022, another cash loan of USD 1.25 million. and the fourth tranche by 1st February 2023, another cash loan of USD 1.25 million. And the fifth tranche is on completion. It is the rest of the cash component as well as all the digital assets.
So
Your Honor,
these are all described as loans? Are they
yes, Your Honor.
that
beg your
doesn't
pardon?
sound like investment as such.
It is, I've been very careful to describe it as a loan, Your Honor, because these first four tranches are in the SSA subject to a super priority application. So it needs to be classified as debt. Until the completion of the SSA, this debt, if the SSA is successfully completed, this debt will be set off against the consideration payable under the SSA for the share subscription. So it will be converted into shares. But
Right,
up until that point,
completion.
yes, up until that point, it has to be
Sorry, a conversion to equity is only on completion.
Yes, Your Honor.
All right.
The longs, if I may proceed, Your Honor.
Yes, yes.
The long stop date of the SSA is set at 31st March 2023, right? Which explains why we are asking for a 4-month extension until 2nd April 2023, Your Honor. As I mentioned earlier, tranches 1 to 4 are to be secured by security given over shares of Zipmex Thailand and Zipmex Thai Subsidiary Co. Limited. That's another company that is co-owned by Zipmex Thailand and a local Thai company. And that security will be the subject of a super priority application that we will be filing very imminently.
You are applying for super priority in December, Mr. Tang.
Yes, Your Honor. Unfortunately,
we haven't given you a date. I think it's a bit presumptuous to assume you'll be able to get a date in December, Mr. Tang.
We will try our best.
What do you mean you try your best, Mr. Tang? You don't seem to understand the tone. I'm very surprised that you're doing all this in December when you know that we don't function in the same way in December.
Yes, Your Honor.
You seem to be taking things for granted, Mr. Tang.
I apologize if I had given that.
No, Mr. Tang, you are taking things for granted. Let me be very clear. You know we don't function in December. Why are you structuring these things in this way? You're asking for a special date in the middle of December, correct?
I was hoping it would be towards the end of December to take.
Yes, and you assume that the dates will be given to you. You should actually, all of you should work with these parameters in mind.
Yes, Your Honor. I hear you.
They should catch you out by surprise, correct, Mr. Tang?
Yes, Your Honor. I hear you. To put things in context, the SSA was supposed to have been signed early last month.
Mr. Tang, I don't really, I do wonder about all this. All these things could have been planned. You know that every year we publish our calendar. I am very surprised that with all this in mind, you still say, oh, we have a super priority application in December.
Yes, Your Honor. The super priority application will be heard when it is heard. I don't intend to hold the court to any court dates that we try to propose, Your Honor. And we will take it back.
I bear that in mind in future. I will try to accommodate, but don't take it for granted, Mr. Tang. All right.
Yes,
I do find our counsel sometimes seem to take it for granted that we will bend over backwards to shift everything else and to accommodate these dates. You should actually plan. Sometimes, to be honest, the courts feel that you do everything else, you get everyone else lined up, but you neglect to line it up with the courts until the very last minute. That is not on. All right, Mr. Tang? All right, please.
Yes, Your Honor.
Convey that to your advisors as well. Line everything up, but don't neglect the dates with the courts. That should actually be the starting point. Then everyone else gets lined up. All right?
Yes, Your Honor. I'll keep that in mind.
I'll give you the dates for the super priority later, but bear that in mind for the future.
Yes, Your Honor. Very grateful for the guidance.
All
Your
right.
Honor, if I may proceed further. Yeah. The SSA itself, Your Honor, is also contingent upon the granting of this extension.
Yes.
Unfortunately, for all 5 companies, Your Honor. Now, if I can move on to the restructuring plan itself for each of the 5 companies, I think Your Honor would have read our submissions and the affidavits. we intend to do it by way of prepackaged schemes of arrangement for 3 companies. This is Zipmex Asia, Zipmex Singapore, and Zipmex Australia, right? Because the main issue in Indonesia has been by order of Bapepti effectively resolved, the investor and the company, basically the group, don't want to incur the cost of going into a scheme for Zipmex Indonesia. For Zipmex Thailand, there is no exposure to Z Wallet because all their assets are held on a custodial basis. And essentially all of Zipmex Thailand's customers, and by this I mean all those customers who are customers of Zipmex Thailand and who have assets only in Zipmex Thailand's wallets, right? They are not creditors in Zipmex Thailand's proceedings, so there's no necessity to scheme them. We are approaching this, of course, from an issue both of efficiency and cost, Your Honor. If we can avoid having to scheme these 2 companies, we would prefer not to do so, right? So that's the plan for Indonesia and Thailand. For
So
Singapore,
could you be clear then, could you state for the record what you intend to do with your Thai customers then?
Your Honor, for the Thai customers in Zipmex Thailand, there is no outstanding
All right.
debt because
So I mean, for the Thai customers who might be in a direct relationship with, sorry, was it Zipmex Asia? What is the plan for them? Could you state it now?
Yes, Your Honor. For the Thai customers who might be in a relationship with Zipmex Singapore because of their participation in ZipUp Plus, the intention is to have them enter into a prepackaged scheme of arrangement.
All right. So for them, it's a prepack as well, correct? All right. Thank you.
Yes, Your Honor.
All right. Carry on.
Your Honor. So for all 3 companies that I had mentioned, we are doing a prepackaged scheme of arrangement. We intend to split the classes into 2 classes. The first is vendor creditors, which is quite straightforward. The second is a class that we have termed customer creditors, which are customers who have exposure to the lockup of the Z Wallet assets. So we have taken the approach that the trade wallets themselves have been fully functional, so there's no need to scheme them because there's no creditor-debtor relationship there. It is the creditor-debtor relationship occasioned by each of the companies withholding of the assets in the Z wallets that need to be schemed, right? For the benefit of everybody who is listening, the plan for customer creditors is to one day have a reset on the scheme implementation date where all the Z Wallet assets become readily accessible to everybody, right? This will be after completion of the investment, which is by 31st March 2023, and hopefully by the end of the extended moratorium, right? The reason why we are doing a scheme of arrangement for these instead of just opening it up is because the investor wants to take over clean vessels, Your Honor, in each of the companies. And for that, there are potentially contingent claims from any customer creditors due to the extended lockup of the Z wallet since the filing of the initial moratorium application. And so any proposed prepackaged scheme of arrangement will have to include such language to waive liability and to release all potential claims. And that's the reason for the prepackaged scheme of arrangement.
So essentially, in stark terms, they will potentially get back what is in their wallets, but no compensation or make up for any fall in the value of the assets in the meantime, correct?
Yes, Your Honor. They will be returned amounts in digital currency commensurate to the amounts in digital currency recorded in the ledgers.
All right.
Your Honor, if I may proceed.
Yes.
Based on this initial arrangement, and let's deal with customer creditors, Your Honor. Based on this initial arrangement, we have around 70,000 customer creditors of Zipmex Singapore. I'm not so concerned about Zipmex Australia because that's a relatively smaller number. So I would like to discuss primarily Zipmex Singapore. 70,000 is not a number which automatically lends itself to an efficient scheme of arrangement, Your Honor, whether it's by a prepackaged method or whether it's by a Section 210. And so what the advisors, the company, and us have come up with is a top-down and bottom-up approach to reducing the number of creditors for the purposes of vote solicitation. Your Honor would have seen in the submissions a brief description of the top-down, bottom-up approach. Essentially, the top-down part involves outreach by the executives and the company and the group to their higher net worth customer creditors to try and get them to agree to a release of liability and a waiver of any potential claims. Basically the same language as in the prepackaged scheme. So if we can get them out of the scheme and settle them separately, we will attempt to do so. We have also mooted the idea of conducting roadshows, both in Singapore and in Thailand primarily. I don't think Australia is so much of a concern, so it's Singapore and Thailand, to get creditors, customer creditors to attend and to explain to them in person, if necessary, why we are doing this, what the company's objective is, and we have pre-prepared forms in English and in Thai for them to sign that will also result in the same potential terms being release of liability and waiver of claims. And if we can get that particular outreach going, we are hopeful that we can reduce the number of voting creditors for the prepackaged scheme. The next step will be the bottom-up approach, Your Honor, which is covered in the administrative convenience class. So essentially, we want to set a threshold of USD 5,000 in value and say that while this class will not be voting in the scheme, as part of the vote solicitation exercise, we will nonetheless treat them no differently from any other creditor, but we will take their votes as having already been cast in favor.
All right, we'll come to that shortly.
Yes.
I have a few questions. The first one is, doesn't the Indonesian action or your basically release of the Indonesian wallets, doesn't that have any impact on the other creditors?
No, it does not, Your Honor, because the release of the Indonesian wallets was an action localized only to Indonesia. The impact to creditors of the other companies was only insofar as assets from Zipmex Asia were diverted to Zipmex Indonesia to allow for this release. So basically, we transferred enough digital currency and cash over to allow Zipmex Indonesia to pay everybody who wanted to recall their assets if they were all to recall it at the same time. That was necessitated by Bapepti's deadline, and it was done because we couldn't sign the SSA.
But doesn't that favor one set above all the others?
Yes and no. Yes, in the sense that if we were looking at it as every creditor is equally weighted in a group restructuring, then yes. But no, also in the sense that each company's restructuring can also be taken separately. It doesn't favor one set of creditors being Zipmex Indonesia's over the others, because Zipmex Indonesia is itself the applicant in a separate set of proceedings, Your Honor. There's no preferential treatment that supersedes the individual nature of each separate application.
But nonetheless, you're using group resources to favor one company in the group over other companies in the group.
Yes, Your Honor. And that was an approach that had to be taken because of Bapepti's deadline.
No, but the thing is, then wouldn't be the complaint be that, let's say, the creditors in Australia will say our regulators should have done the same thing, and perhaps regulators in Singapore and Thailand should have done the same thing?
Well, I'm not about to make any suggestion to any regulators to give such ultimatums.
Can I just answer the question? Isn't that favoring, basically responding to the needs of a regulator in one jurisdiction? So wouldn't the others in the other jurisdictions have concerns? They will say, oh, we should have gotten our regulators to do the same thing.
Well, Your Honor, the Indonesia reallocation was deliberated upon very deeply by the directors of Zipmex.
No,
and all these
that's irrelevant, Mr. Tang.
Yes.
I don't care whether they were thinking about it, whether they were deliberating overnight or whatever. But the thing is, the effect of doing this for Indonesia, wouldn't that mean that the others in the other jurisdictions are actually prejudiced in that they were not afforded the same opportunity and you're favoring one over the other? And it makes a mockery, doesn't it, of the application by the Indonesian entity before us. If this was going to be the outcome, what's the point of the moratorium in Singapore in relation to the Indon, or the application in Singapore in relation to the Indon entity? We would have expected the 65C applications, when they are made, to be indicative that there will be a group restructuring where the actions would actually benefit and affect the companies in question altogether. But in the meantime, what you've done, without informing the court at the time, is to actually take out one of the companies and basically leave the others in the same position they were. I don't really care whether the directors took a long deliberation of it, but the thing is, you have actually nullified your 65C application, correct?
Your Honor, we didn't apply under 65C. There was 64. Yes.
All right.
I mean,
didn't you apply for the Indon entity?
Yes, Your Honor. And
right.
the Indonesia, if I may, Your Honor, the
Yes.
Indonesia reallocation, which is the divestment of the assets, was specifically provided for in the SSA. So what?
I don't care. You don't seem to understand my concern. You're not addressing my concern at all. I don't care what your arrangements are between yourselves. You've got this kind, you've brought in all these companies, and then you favor one over the other. Whether the regulators want you to do something like that, that's between you and the regulator. But you've got these groups of companies before the court, and then you do this carve out without coming back to the court, telling us what's happening. And on what basis then would the court want to maintain the position in relation to the other companies?
Yes, Your Honor.
I really don't care what the directors thought. We've not come to that yet, but I do wonder whether this is cavalier attitude that, oh, we'll make whatever arrangements at the time, we'll respond to whatever needs to be done, regardless of the status of the proceedings in Singapore. Do you understand my concern, Mr. Tang?
Yes, Your Honor, I hear your concerns.
I want an explanation for this. Or is your explanation really, this was what we had to do in Indonesia, that's it?
Well, Your Honor, the explanation is very basically, very basically, that if the 4th November deadline had lapsed without the Indonesian
No, that's a matter of
entity,
commercial thing. You are not giving me an explanation of why you did this in the face of your application in Singapore for these protections.
Yes, Your Honor.
No, this is not on, Mr. Tang. At least inform the court about what you're planning to do. I am not chopped liver.
Yes, Your Honor.
No, there's no explanation before me, right, Mr. Tang? You just did it.
Your Honor, the explanation was to maintain, as Your Honor says, it was a commercial decision.
No, yes, but you are not in just a commercial thing. This is not a situation where you just get to do whatever you want. You invoke the court's protection through the moratorium, and yet you do this.
Yes, Your Honor.
This is really not on, Mr. Tang.
What I will say, Your Honor, is that it was a difficult situation at a time with no good outcome.
Again, the courts are what? An afterthought. You just sorted out among the financial advisors, you sorted out among the directors, and you only tell the court later. I really feel like chopped liver, Mr. Tang.
Your Honor, that was never our intention.
That may not be your intention, but that's the effect.
Yes, Your Honor. I hear Your Honor on this, and we will ensure that that never happens again.
I'm not certain whether there really isn't any prejudice to anyone else, but all right, it is done. I can imagine that some of your creditors in various jurisdictions, whether they're direct creditors of some of the entities or whether they're creditors of Zipmex Singapore, will be quite upset. I don't know whether you're going to create more difficulties for yourself in doing this in this way, but all right, it's done. I'll revisit the consequences later. All right, the other question I have. Some of your payments from your investor will be in cryptocurrencies. Cryptocurrencies are in a state of volatility.
Yes.
Are you really getting good value, Mr. Tang?
The thing is, Your Honor, the thing is that the exposure of the group to the Babel Finance Group is also denoted in cryptocurrencies.
Yes.
So when they insert cryptocurrencies into the group, right, to replace or to top up the exposure to the Babel Finance Group, it is a 1-for-1.
So no impact from the volatility.
No impact on the no impact from the volatility. Yes, I would say.
That's your position. All right. Any exposure to the other entities that are currently in difficulties or Chapter 11, including FTX? I can't remember who others.
No.
No exposure.
No exposure.
All right. Your super priority application, I'll give you a date in mid-December, after the 18th. Is that likely to be feasible, Mr. Tang?
I apologize, Your Honor. You cut out for a little bit after your
Sorry,
super priority application.
probably would a super priority application work between the 19th to the 23rd?
A hearing, Your Honor?
Yes.
Yeah, we can work with that, Your Honor.
All right.
We will file it very quickly.
I'll give you a date on the 21st of December. All right. Registry to confirm. All right. Now, let me come to the administrative convenience class application.
Yes.
The difficulty I have, Mr. Tang, is that, well, aside from the substantive issues, that you're affecting a very large number of people, basically depriving them of any say for the benefits on the basis of convenience. What is your basis, not so much for the power of the court, what is to make an order approving the administrative convenience class, but what is the basis for you asking the court to do so? What power are you asking me to invoke? Yes.
Your Honor, well, the first thing that comes to mind would be the liberty to apply provision for the court to make orders under the moratorium prayers.
That's the moratorium prayers. This has nothing to do with the moratorium. I don't think that's a starter, Mr. Tang. And
yes,
to cut it off, I don't think inherent jurisdiction is going to work either. Yeah.
Yes, Your Honor.
So the difficulty I have is that I cannot see what power I can use, certainly not liberty to apply or inherent jurisdiction. There's nothing within the scheme of Section 71 or ERDA, I think, that will enable me to make this kind of order. It's not contemplated for the court to come in before the pre-pack application is made, I think.
Sorry, Your Honor, I'm just scrolling down to
Yes.
Section 71 as well.
Um,
I mean, generally speaking, Your Honor, since this is an application that is subject, or rather the entire proceedings are subject to the court's oversight and it's a court supervised restructuring, we thought it best to litigate such issues at this stage.
Yes, but
Your
how
Honor,
do I meet the power? Because I have to have the power to entertain the application in the first place. How are you going to invoke that? I'm afraid I cannot see how you can do this. This is more almost the best I can think of is a declaratory application, but you then will have to jump through the hoops for declaration being made, including our requirements for parties affected to be joined. And so therefore, I don't think it's going to be very feasible for you to pursue the declaratory route. Right, Mr.
yes,
Tang?
Your Honor. Yes, Your Honor. I hear the call on this.
Yes.
Unfortunately, I don't have a.
All right, so that's one problem. The other problem is that even if I could entertain the application, the question is the second question would be what power do I have to basically create such a class? You've, of course, pointed to US authorities, but the US has a specific statutory provision. I note that the US courts may have done so before the statutory provision. I seem to get that from your submissions, but unless you want to go through the historical US cases and why they did so and what powers they invoked, I'm not sure I can do the same anyway here because in relation to pre-pack, the pre-pack framework, I have to operate within the ambit of the statute, and I don't quite see that there is anything for me to basically be allowed to bless such a structure before the application comes to me. I don't see that within the framework created by the legislature, and I must operate within the confines of the legislature. All right?
Yes, Your Honor. Yes, Your Honor. I hear the call on this.
What I can indicate at this time is that it doesn't strike me as the kind of thing that would be immediately ruled out of bounds. I can see some force in it, possibly, but subject to any argument someone else might raise. My primary concern is the prejudice to the creditors who are affected. But at the same time, I acknowledge that some measures may need to be taken to make the pre-pack feasible. So I'm not ruling out a similar mechanism that if you set up such a class that it will be potentially ruled kosher, but it depends ultimately on what I hear when the application is made. So basically, I can't rule on it at this time, but I may be able to rule on it when the application, the pre-pack application is brought up for approval. As I said, I don't see anything that will make me say that it's not an arguable point.
Yes, Your Honor.
I think that's about the best I can go at this time, unless you can point me to answer both things. One is what is my jurisdiction to hear this application, and two, what specific powers are contemplated under the statutory framework. All right.
Yes, Your Honor. I
Do you want to
do
take
believe-
instructions? Do you want to take instructions on this? I can stand down for a while if you want to do so. Or if you are able to state your position at this time, given my comments, we can go ahead.
No, Your Honor. I don't believe I am required or I require a period of time to take instructions on
Alright.
this. I can respond
Yes.
to say that any jurisdiction that we would have identified for the court to make an order on such applications would have been inherent jurisdiction, which the court, which Your Honor has indicated that is a no-go from the start.
Yes.
Or alternatively, the jurisdiction conferred on the court under the SCJA, which I suspect Your Honor would also look dimly upon in this case. So if Your Honor is of that view and is not with us on our ability to obtain such orders at this particular time, we would thank the court for Your Honor's guidance on the same,
Mm.
and we will deal with this at sanction.
All right. So you take it subsequently. All right.
Yes.
All right. What I would strongly suggest is if you're pursuing this to really communicate to the affected persons. And your position is they don't suffer any prejudice insofar as ultimately they will get their, if the scheme goes through, they will get their, at least the amount of cryptocurrency that they had in their wallet in March, right?
Yes, Your Honor.
All right, so you should explain the pros and cons to them, right?
In July, Your Honor.
But also in
yes.
July, all right.
Yes.
All right. Anything else, Mr. Tang?
No, Your Honor, unless I may be of further assistance. Oh, actually, Your Honor,
Yes.
I think maybe it would be remiss if I don't raise that there have been no objections to the applications. There has been one supporting customer creditor, I believe it's a creditor of Zipmex Singapore, and we haven't received any objections.
All right.
Notwithstanding that, notwithstanding that there are quite a few creditors, and we don't suppose that all of them will write to us to state their position. Your Honor will recall that at the initial hearing of the moratorium extension, there were quite a few customer creditors who had actually written to state their objection, and that's not the case today, Your Honor. So I just want to highlight that.
All right. I mean, there could be various reasons for that, but all right, we'll see. All right, I will open it to any of the attendees to indicate if they wish to be heard by me. So basically, in summary, there's an application for extension of time until March for the companies to put together a pre-packed scheme, meaning that they will put forward a scheme to the court that would have obtained approval from all of you. And under this scheme, basically the investor will ultimately put in money that will be converted to equity, and all of the account holders will get back at least the crypto face value amount in their accounts by July. But in return for this, there will be waiver of any consequential losses or contingent losses. So that's the trade-off in these circumstances. There was a second application for the creation of what is termed the administrative convenience class. This was basically to gather all those persons who had $5,000 or less into a separate class who will not be indicating their vote at all because of the sheer number. And basically they will be taken to have approved. Now this kind of mechanism is used in the US for convenience for where there are many smaller value creditors. What I told Mr. Tang is that I didn't think I could entertain this application at this time. There is no mechanism for this in Singapore. What I think they had to do is to go ahead with the pre-pack, do what they think is feasible, and then apply for court approval after everything is done. So our statute doesn't allow them to put the question to me at this time. All right, so that is the summary of what has happened. If any of you wish to say anything to me, I can give you some time. You just need to indicate to my manager that you wish to speak. Any, let me know, please.
No one raised.
No one has raised. All right, thank you. All right, Mr. Tang, let me just go through the summons. They're all in the same form, correct?
Yes, Your Honor, save that the summonses for Zipmex Singapore and Zipmex Australia have additional press 3 and 4, which is to deal with the administrative convenience class.
All right, let me just make sure I've given the appropriate order. So 4325, I've given the order. Is this in your bundle of documents?
No, Your Honor, it was
Thank you.
inadvertently left out. I
That's all
apologize.
right.
We have,
Sorry, someone has raised their hand.
yes,
All right. Can we promote the person, please? And I'll hear the person out.
yes,
Sorry. Hold on. Who is that, please?
Navita Derkut.
All right, thank you. All right, sorry, is this Mr. Navita Direkut? Are you able to switch on your camera, please? All right, thank you. You can turn on your microphone. What do you wish to say, Mr. Navita?
Sorry, could you unmute yourself?
Yes.
Can you hear me, Your Honor?
Yes, thank you. All right, your camera is a bit off, please, Mr. Navita. Yes, thank you. That's better. All right, what do you wish, Mr. Navita?
Can you hear me, Your Honor?
Yes, thank you. Yes.
Yes. My question, I'm a creditor in Thailand. I've been affected by my cryptos up in the Zip Up Plus. I'm very happy that Your Honor has been
Sorry, Mr. Navita, we've lost you for a bit. I think there's a bit of lag.
all of us over here.
Sorry, could you?
Is the connection okay now?
Yeah, it's okay now. Could you repeat what you just said, please?
Yes. My great appreciation to Your Honor. You've been a great help to all of us over here.
Thank you. Yes.
My question is, the prepackaged,
Mhm.
is it going to be, the cryptos will be available to us? Is it in March or is it in July?
All right. I believe it's July, Mr. Tang.
No,
Oh, sorry.
no, Your Honor.
Oh, sorry.
The crypto will be available. My estimate will be April,
April. All right. Sorry.
towards the end of the moratorium. Yeah.
Towards the end of the moratorium. So your moratorium, you're asking for an extension to March.
2nd April.
2nd April. Sorry.
Yes.
All right. So from the end of the moratorium onwards. Is that correct, Mr. Tang?
Yes, Your Honor. On completion and after the schemes pass.
All right. Why did the July date come up?
Because Your Honor had asked when was the date at which they would be, or when was the date at which their debts crystallized, Your Honor. And I said July because it was July 2022 when we filed the initial moratorium application.
All right.
That's
so
when the Z wallet was locked up.
So basically, cryptos will be available for withdrawal from early April. That's the forecast. Correct, Mr. Tang?
Yes, Your Honor.
All right. So, all right, Mr. Navita, that's the answer.
Thank you very much, Your Honor. You've been a great help to all of us. Thank you.
All right,
Have a good
thank you.
day.
Thank you, Mr. Navita. All right. And okay. All right. I think there are no other questions. All right. Thank you. All right. Let me just go through the summonses. All right. Let me take 4184. All right, for each of the summonses then, order in terms of praise 1, 2, and 3, and in relation to, was it 4187 for Zipmex Australia? All right, which is the one that's in the same form of as 4183? 4187, 4186, was it, Mr. Tang?
I think it's 5, Your Honor, but I am checking that on my end
Yes.
now.
That's the one with the administrative class, correct?
Yes, this is the one filed in OA 382. I apologize, Your Honor. I don't necessarily have
All right. Hold on a
The
moment.
problem, yeah, I don't.
Just make
Yeah.
sure I've got everything. All right, 400 is not the same one. 4185, was it, Mr. Tang?
Yes, Your Honor. So it's 85 and 87.
All right. All right, sorry, that's right. So for the summonses with the administrative class application, only order in terms of prayers 1, 2, and 3, no order on prayer 4. All right, so as I indicated, the arguments in relation to the question of the administrative class will have to be, administrative convenience class will have to be taken up at the time of the pre-pack approval subsequently. All right.
Your Honor,
Mhm.
just to clarify the orders made for 4185 and 4187, prayer 3 is actually that the company be at liberty to classify all unsecured.
Oh, sorry, my mistake. Yes, for orders in terms praise 1 and 2, correct. No orders
1,
on praise
2,
3.
and 5, Your Honor?
5 is liberty, is it? All right.
Liberty, yes.
All right.
Yeah.
1, 2, and 5, order in terms, no orders as to prayers 3 and 4. For the other summonses, order in terms praise 1, 2, and 3. All right, so basically no orders in relation to the administrative convenience class.
Yes, Your Honor.
All right. Can I suggest that if you are pursuing this subsequently, since I recall there was some reference to the US cases, even prior to the statutory regime being made clear, that it might be useful to indicate to me how the US cases approached it before then. All right.
Yes,
That
Your
might-
Honor.
And otherwise, if you need to invoke some power on my part to do it, I will entertain it. I'll be open to it, but I think you have to be aware of the limitations of invoking inherent jurisdiction or even the SCJA.
Yes, Your Honor.
All right. All right. Thank
Yes,
you.
Your Honor.
All right. And if anything else crops up, especially in relation to anything like the Indonesian situation, as I said, it's a matter between you and the regulators, but please let the courts know at the juncture, all right, and not subsequently. All right.
Yes, Your Honor.
All right. All right. And otherwise, super priority hearing on the date I indicated, which was, sorry, what was it? 21st December,
21st December.
10
Yes,
a.m. Registry will confirm. All right. So please disseminate the information as usual.
Yes, Your Honor.
All right. All right. Thank you, Mr. Tang.
Thank
Anything
you, Your
further?
Honor. Good day.
All
No,
right.
Your Honor.
Thanks, brother. All right. Thank you. I hope everyone has a good end of the year. And we will have the next hearing on the 21st of December for the super priority application. All right.
Yes,
Thank
Your
you,
Honor. Grateful and good day.
All right. Thank you for your assistance, Mr. Tang. All right. Court is adjourned.